The application of a force majeure clause is especially fact and contract specific. Understanding what constitutes a force majeure is critical so you can avoid being unprepared. Hope everybody's doing well. Today I have some information about force majeure that's critical to understand, especially during the pandemic. A force majeure clause in a lease typically lists unforeseeable events that will excuse or delay a party's performance under the lease. Force majeure clauses are normally triggered by events such as civil unrest, acts of God, natural disasters, terrorist activities, governmental strikes or orders, labor strikes, or war, etc. Some clauses even list epidemics or pandemics as triggering events. The coronavirus pandemic may constitute a force majeure even if pandemic or epidemic is not included in the lists of triggering events. For example, a court recently held the force majeure provision in a restaurant tenant's lease that included government action and orders was triggered by a government order to close restaurants. The court ruled the tenant was only required to pay rent in proportion to its ability to generate revenue, and determined only 25% of the rent that became due during the government order was to be paid based on the tenant bringing in 1/4 of its pre-pandemic income from takeout orders. This is something to keep in mind these days especially, and it's important to get legal advice regarding a force majeure's application to specific events, since the application of a force majeure clause is especially fact and contract specific. Please hit like if this information helped you. If you want relevant, quick updates and tips every Monday, subscribe to Thomerson Law. We'll be covering more topics like these and other topics critical to know, especially during COVID, each Monday. Stay safe and stay in the know. See you next Monday.